for coming this morning. What we have here is, I guess it's a mandatory requirement of the state that all supervisory personnel have a 30-minute training session on our drug and alcohol-free workplace every year. And we have here with us Mr. Gary Moberly of Gary Moberly and Associates out of Versailles. We've used him as our
consultant.
Consultant. There was the word I'm looking for. As our consultant in getting this done, and he's done a very fine job of working with us and helping us out to get this certification. And so we're going to be on TV, and what that will allow us to do is in future years, Gary won't have to come down here, but we can have DVDs and you can watch back at your place of operation, and you won't have to come out here. Gary is retired from the Kentucky Labor Cabinet, where he was Executive Director of Mediations and
Labor Management Relations and Mediation. Yeah.
And he's been here before to give training. I think the group that was here before found him to be very
I hope so.
knowledgeable and so forth. So without further ado, I'm going to turn this over to Gary Moberly.
Thank you very much, Judge. As Jim said, there is a requirement in the regulation that governs this drug-free workplace certification program. And you all, by the way, were the first county government in the state of Kentucky to obtain this important certification. Kind of bragging rights, if nothing else. And you're one currently of only 5 who've been certified. I'm working, Jim, with about 7 others right now in various stages of the process, but you all were the very first in the state to get it. The regulation that governs the program does require that supervisory personnel get the 1 hour of training that you've already gotten. Jim put an excellent program together, and it was so good, I said, there's no need in you paying me to come back down here and do the hour presentation. So he said, well, we'll let you come down and train. We do want you to come train the supervisors. And then their video, as he said, they're videotaping today, so in the future, maybe, Jim, we can at some point update it a little bit and try to keep new information in it so it won't get boring for people every year. Want to run just some numbers by you guys to start with. You're already aware that everybody knows that substance abuse out on the streets and across our country, and particularly in the state of Kentucky, is a major problem nowadays. I've been dealing in employer-employee relationships my whole career. That's what I do as a consultant, all types of mediation and employee-related sort of stuff. But I've dealt with it my whole career and never realized, even though I dealt with it at the bargaining table between unions and companies that I worked with, and I do a lot of EEOC kind of mediation between the U.S. Social Security Administration and their employees in the southern states, and I'd run into it there a few times, but I never realized what a major problem it's become in America's workplaces and in our workplaces in Kentucky. There was a study conducted recently by the United States Department of Health and Mental Services and the United States Department of Labor jointly, and it reveals some important statistics that everybody needs to be aware of if you want to work safe. Who is the responsible party? Let me just ask this question up front. Who's the responsible party, legally responsible party, for creating and maintaining a safe and healthful workplace in America? Who's legally responsible for that? I always get the same reaction because it's not something people have to deal with every day. But it's the employer that the federal occupational safety and health people and the state occupational safety and health people hold responsible to do everything they can possibly do to create and maintain a safe and healthful workplace for people who work for a living every day. As I look around the room, I see these neon vests and coats that people are wearing. That is the Hardin County Fiscal Court, I assume, supplying those for you all. That's one of the things they do to try to keep everybody safe. But I can tell you, after having spent my whole life working around as a wage and hour and overtime and particularly child labor investigator, working around the occupational safety and health people, I can tell you, 38 years of my life's been spent there, I can tell you that if you want to go home at night with the same amount of arms and legs and fingers and toes and eyeballs that you came to work with, at the end of the day, safety is everybody's responsibility. No question about that. And I want to throw some numbers at you to let you know what a problem it is in America's and in Kentucky's workplaces, so that you'll understand we can no longer safely assume that we don't have a substance abuse problem in our workplace. This study that I am talking about indicates that 70%, almost 3/4 of everybody in America who are abusing substances, not just using, but abusing substances, and abusing them according to formulas that are developed and established by the Drug Enforcement Agency and the federal government, and the United States Department of Health and Mental Services. They actually have a formula that says what constitutes abuse of any substance on the list. For beer, for example, it's 6 beers per day over a certain number of days, certain number of months and weeks constitutes abuse of that substance. And what they're not talking here about the couple who goes out to dinner with their next door neighbors, has a couple glasses of wine or beers and goes home. They're talking about people who abuse substances every day of their life and every night of their life. And they also say in this study that just because they go to work doesn't mean they stop abusing. They find a way to do it at work. But they're saying that 70% of everybody who abuses, according to these substances, are on somebody's payroll. I would have thought it would have been just the opposite. Now, I've been in this business my whole life. If you're abusing substances, how can you hold a job? Not true, according to the U.S. Department of Health and Mental Services and the DEA. They are working. They are gainfully employed on somebody's payroll. The same study I'm talking about says that it may be assumed in 2010 that 10 to 15% of any workforce in America on any given workday in any given workplace is working impaired on one substance or another. Now, that's a scary number. So it's no longer safe to assume we don't have that problem. And it should not be assumed if you all and the people you supervise expect to go home safe at night, back to their families like they came to work. What I'm going to do this morning is talk briefly about recognizing the signs and symptoms of substance abuse. You probably got some of that in the presentation that Jim gave you. More importantly, how to document reasonable suspicion. If someone is suspected of substance abuse, and that's really the primary reason they want supervisors to get an extra half hour of training under this program. There are some legal and practical connotations that go along with reasonable suspicion testing, and it's just one reason for testing. There are a number of reasons under this policy people can be tested. But reasonable suspicion is just one reason. But there are some legal and practical aspects that come into play in reasonable suspicion testing that supervisory people need to be aware of, because it's you all. You all are the front line as supervisors in Hardin County who are primarily responsible for acting upon information that somebody may be using a substance or may not be. It's up to you all to begin the process, but I want you to understand you're not in this process alone as supervisors. It's going to be you all documenting the process and working with Jim, because Jim has final responsibility to make the final determination, yes, there's enough evidence that we need to have this person tested for reasonable suspicion. The reason the courts have checked in on reasonable suspicion testing in any case is that at some point somebody must have made an issue of it. Being tested for reasonable suspicion, and the courts have said, and for you police officers, reasonable suspicion is just a standard, but it's not nearly as high a standard as what you guys have to deal with in terms of probable cause. Probable cause will get you convicted of a crime. Reasonable suspicion is just a standard. The courts have said there are some things we want people to consider in having a person tested, and they're not by any means saying if there's evidence that somebody's using drugs or alcohol in the workplace, by all means have them tested for reasonable suspicion. They're not saying don't do it, but they're saying If you do, and it becomes an issue in this court, there are some things in terms of documentation that you need to be aware of that we're going to be looking for, that we want to see present. Now, that's not brain surgery. We have developed for you a reasonable suspicion testing form. I think Jim's going to be using that, and it will be available to you that you would use to begin the documentation process. But after having spent my whole career, 30 years of my life in government as a government employee, I can tell you one of the first things they taught me as a wage and hour inspector is when you work for the government, document everything you do, particularly if you're in a management position, you're dealing with employees. Document it. You cannot have enough documentation. I've still got a file that thick in my files at home of notes that I made over a 30-year career, and in some cases it was where somebody I was supervising, their performance tended to drop off for one reason or another, and I was trying to figure out why, and I made a note to myself and put a date on it. Mary's performance is dropped. Something's wrong. Could it be drugs or alcohol? Question mark. That's the time to start, not when you're already in a crisis. If you suspect it, then make a note of it, because you can't have enough documentation, okay? But we're going to talk about how to document, how to refer people to the Employee Assistance Program, and that's a requirement for certification that there be an Employee Assistance Program in place. Your Employee Assistance Program here in Hardin County is Humana, place you all buy your health insurance, and it's a confidential number, and the reason that's in place is that they're trying to encourage people to voluntarily seek assistance if they think they might have a problem with substance abuse. People who voluntarily go do something about it before they're caught in a test have a much higher rate of recovery statistically than people who are made to go do it. These police officers see the same people back out on the street time after time for DUI, and one of the reasons is they may go to court and the judge may spank them on the behind a little bit and say, go to AA meetings for 3 months and bring me proof that you've been to AA meetings back. When they complete the process, they're right back out on the street. But when a person voluntarily knows they got a problem, and it might be prescription drugs increasingly becoming a problem. Some of you may have heard about the EMT in Louisville. EMT was using a prescription medication. I've since learned that it was not her prescription, it was somebody else's. And here's the sad part about that situation in Louisville. 2 of her co-workers were aware that she might be using a little bit more of this prescription. They didn't know it wasn't hers, but she had a pain problem, not unusual for an EMT. They do a lot of heavy lifting. And they felt like, they knew she was taking a prescription medication, felt like she might be using more of it than she ought to, did not say anything to her about it, did not go to the supervisor and say anything to the supervisor about it. She got a call to go pick up a patient out at Shively, ran lickety-split out there, put the patient in the back of the ambulance, running lickety-split to the hospital, had an accident, and it killed the patient in the back of the ambulance. Now, not only does the city of Louisville apparently have a substance abuse problem, they now have a huge liability problem on their hands. And that's just one city in this state, just one city. So everybody needs to be aware that those kind of things happen with prescription medication as well, an increasing problem. We're going to talk a little bit about the EAP, and then we'll talk briefly about the legal and the practical aspects of reasonable suspicion testing. If you think about that 70% number, if 3/4 of the people in America who are abusing substances, according to formulas, are on somebody's payroll, it may be a little bit harder to recognize it at work, because apparently if that number's true, and I have no reason to doubt these statistics, if that number's true, somebody's doing a pretty good job of hiding what they're doing in the workplace. 70% of them are able to hold a job. I know people who do it every day at work. Make no bones about it. But it might be hard to recognize. So supervisory people have a much more stringent responsibility, I think, to pay very close attention to the people you supervise. You all know them better than anybody else probably in county government. A lot of them trust you as supervisors. But you need to be very much aware of what's going on with your people. Listen and watch closely. If it can be assumed that 10 to 15% of anybody's workforce is working impaired, don't assume that it's not happening. Simple as that. And we have developed the reasonable suspicion form. If you need it electronically, I'm sure Jim will send it to you electronically so you'll have it in hand. You can use that to document your thing. And feel free, Jim, it does have a copyright mark on that form. Feel free to toy with that any way you need to suit your own purposes based on what your needs are in your department.
Each department has copies of these.
I'm sorry?
Each department has copies of these.
Good, yeah. Well, the first place you want to go if somebody comes to you and says, Joe's drinking today, or I think Joe's using drugs, or for whatever, prescription medication or whatever, go pick up a copy of the reasonable suspicion form. And that begins your documentation processes, and that's what the court expects to see. It's got signs and symptoms on it, plenty of space to write. If someone were to come to you and say that, fill out, it doesn't have to be 5 pages long, fill out a statement. Doesn't have to be a sworn statement, just a statement. Here's what I saw, here's what I observed, and put a place for them to sign their name. And ask them to sign it. If they want to be safe, it shouldn't be a problem for them to sign a statement. Let's face it, nobody wants to rat on their coworker. But in this case, we're talking a major safety issue here that affects maybe not only that person's personal safety who comes to you, but the safety of the person who's using, or perhaps, in the case of a county government, the safety of private citizens. So don't be afraid to ask them to sign a statement, and if they choose not to sign it, write it out for them, have them sign it. Here's what I saw, here's what I observed. If they choose not to sign it, just make a note of their name and say this employee opted not to sign this statement. That's part of your documentation if you were to end up in a courtroom. You can't what I tell supervisors is picture yourself in a courtroom. Somebody's made an issue of being tested. Doesn't happen every day, but somebody's made an issue of being tested, and you as the supervisor have to go to court to try to prove why you had them tested for reasonable suspicion along with Jim. And do I have enough documentation to indicate that it was a reasonable thing for me to do or for the county to do to have this person tested for reasonable suspicion? Simple as that. Basic signs and symptoms, you all have been through this before, I'm sure. Unable to maintain normal balance, bloodshot or watery eyes, odor of alcoholic beverages, not alcohol, because alcohol has no odor. Alcoholic beverages, each individual type of alcohol has an odor. Whiskey, for example, is made and aged in a charred barrel. It gives it a distinctive odor. But odor of alcoholic beverages or marijuana on clothing or breath, abnormal coordination, recurrent nausea or vomiting in people who don't ordinarily do that. It might be that they're just sick. Doesn't mean they've necessarily used drugs or alcohol, but according to the U.S. Department of Health and Mental Services, if it's happening a lot, it could be a sign or a symptom. Obvious extreme fatigue or sleeping on the job, flushed or abnormally pale face. All those are signs and symptoms that are listed on that reasonable suspicion form. And you can find even more if you want to go online to the DEA or the U.S. Department of Labor. They've all got these drug-free workplace sites, and you can go on there and find even more signs. Now this is really important, apparently, the court system. Any sudden decrease in the performance of an employee. As supervisors, you know what your employees what they're capable of doing and what they're not capable of doing. And you know what their normal behavioral norms are because you work with them and supervise them every day. So anything that's different in terms of their performance, that seems to be real important to the court system. Most of the information I'm giving you here is based on actual court decisions regarding reasonable suspicion testing. But in all cases, always refer to that reasonable suspicion form because that puts it down on paper and it indicates that you as a supervisor, along with Jim, have made an effort to document what happened. That's what they want to see in the courtroom. On the reasonable suspicion form, there's a place for the employee's name, the date, the time, and location of whatever happened. Was there witness involvement? If there was, ask the witness to sign a statement. Attach that to your documentation. And then if it got to the point, obviously, if somebody comes and tells you that, you can't discount it. You're probably going to go make an observation and make a determination as to whether you think there's enough evidence based on signs and symptoms or whatever, their performance, whatever, to take it to Jim. But it's your documentation that's going to either convince Jim, yes, we have a reason to test this person, or no, we don't. So you can't have enough documentation in the process. You're not in it alone, though. Jim will be with you on this. But what action did you take as a supervisor? Did you go observe? Who did you take with you to observe? And then, perhaps more importantly to the courts, what was that employee's response? Some people who are abusing, all they need is a nudge, and they'll say, yeah, I am. But a lot of people may get a little hostile about it, and you've got to be prepared to deal with that as well. These officers see it every day out there. Now, here's what the courts say that your documentation should provide. Very employee-specific evidence of any performance problems or the actual observation by anybody of the intentional misuse of controlled substances or alcohol in the workplace. And they want the information you provide to be objective, and they just want the facts, ma'am, just like Joe Friday. They don't want speculation. I think this happened, or I'm not sure if it did or not. They want facts. And the more facts you can list, probably the better off you are in terms of reasonable suspicion testing. And they want that information, they want those facts to be objective. And by that, the court means, and I use this simply as an example, let's say you've got a John and a Joe who work for you. And as supervisor, you constantly are having to referee little spats between John and Joe. I always see a lot of knowing smiles because it happens to a lot of supervisors. You're aware that John and Joe don't necessarily care for each other a whole lot and would rather not have to work with each other because you're constantly having to deal with little, might just be a personality conflict they have, but you have to referee. They simply want you to take that fact into consideration in starting the process of reasonable suspicion testing. That's all they're saying. Just please be objective. You may not like Joe so much either. And John comes to you today and says, I think Joe's drinking. Well, you know, you need to take into consideration that you're constantly having to referee little battles. That's just another in the process. Don't assume that Joe's not drinking. Go check it out as a supervisor. And don't assume for a minute that it's not happening, because remember the numbers I just gave you. It could be happening. But don't assume that it's not. But use objective and factual information. And again, what's Joe's performance picture been over a period of time? Might have been an excellent employee, never given you a minute's trouble, gets along with everybody but John, and suddenly Joe's performance starts to dip. Starts calling in sick a lot on Mondays and Fridays. That's a classic sign or a symptom. Maybe Joe's appearance is not what it normally is. Joe normally takes very good care of himself and keeps himself real clean, and suddenly he's disheveled every day. You caught Joe sleeping on the job a couple weeks ago. All those would indicate, maybe, excuse me, got a bad cold, would indicate that Joe might have a problem. So they're real interested in you documenting what Joe's performance picture has been over a period of time. I guess you all have some sort of evaluation system here where supervisors evaluate, do you? Well, whether you do or don't, if you do have employees, and you all obviously supervise other people, it doesn't hurt to document performance issues anyway. That way you're always covered. If something happens and you need to let somebody go, whether there's drugs or alcohol involved at all, you've got documentation. I've dealt with employment relations my whole career. Documentation is extremely important. It can be a means to prevent future meetings with Joe regarding his performance, but it also can be a means to prevent it being Joe's word against yours if you look at it the right way and handle it and document it properly. The courts have ruled that reasonable suspicion, that's up a little high maybe, reasonable suspicion has to be more than just a hunch. It can't be, I think this happened, or I thought that might have happened, or somebody thought that happened. Has to be more than that. They want it to be based on facts. Here's what happened. Here's exactly what happened. They want facts. And it has to be based on a belief that an employee is using or has used drugs in violation of what you got in the policy. And I encourage all supervisors to know what's in that policy. It's up to you guys to read it, know what's in there, because somebody may just come and ask you, what's this mean? And as a supervisor, you should be able to answer that question. The belief must be drawn from specific, objective again, and facts that can be stated intelligently, and what inferences a reasonable thinking human being would draw from those facts in light of their experience, training, or education. That's what the court says. That's a quote, actually, out of an actual court case. That's what they're looking for if you're going to make reasonable suspicion testing stick. Has to be based upon, while at work, any kind of abnormal conduct. You all know how people act on a day-to-day basis. Any kind of erratic behavior that's not a part of what they normally would do or act, or a significant deterioration, again, in the employee's job performance, how they normally perform. They're not able to complete tasks on time. Something's wrong. You know it is. It might be that they got a sick kid at home. Doesn't necessarily have to be drugs or alcohol. But as supervisor, it's up to you all to know a little bit about what, how people normally act or react. If you supervise somebody every day, you're going to know a little bit about their family situation, probably going to know if they've got a health problem. You just know those things. You work with somebody every day. Any evidence that an individual has tampered with a drug or alcohol test during employment with the employer, they'll try to sell you 100 things nowadays online to try to mask whatever you got in your system so you'll pass the urine test. But they actually have technology in these laboratories now that do the analyzation of these samples, these urine samples, to even be able to tell if you got a masking agent in your system. So it's become a pretty foolproof deal. A medical review officer, if a test does appear to be positive, is going to do a complete investigation, and that's got to be somebody with an MD. It's going to be a doctor behind their name. That's going to do the investigation. And they'll actually call the employee and say, what kind of over-the-counter medication you've been taking for the past 60 days? Are you taking currently any prescription medication? They will eliminate any medical or biomedical reason why that person might have tested positive for marijuana or codeine or cocaine or whatever is in that 11-panel test that's required. Or information that an employee's been involved in an accident at work. Or evidence that an employee has used, possessed, sold, solicited, or transferred illegal or illicit drugs, or used alcohol while on the employer's premise, and I would add to that, your policy goes even further than that. If you're on county business while off county property, this policy still applies. I need to add that to my presentation. Or while operating the county's vehicle, machinery, or equipment. Just remember that reasonable suspicion testing does require, if it gets to court, a lot of documentation. You ought to do it anyway, whether it gets to court or not. That way there can never be a question, and you and the county are covered. And encourage all employees to notify you, because it's you all who have to start the process, put the documentation together. If someone is suspected of, it might be a private citizen who comes to you. Says, I saw one of your employees driving a pickup truck, looked to me like they were drinking. You got to check that out. Now, we're going to talk about the EAP just a minute, Humana is the county's provider of choice for EAP services, and a lot of people don't realize the value of an EAP. I think under Humana you get 3 visits per year per problem that you might encounter. Might be more than that, Jim, I'm not sure. But if you have to go pay for counseling services in 2010, it's going to cost you between $150 to $200 an hour. And they do not just drug and alcohol counseling, they do marital counseling, divorce counseling, financial counseling, and you get 3 free visits per year per problem that you encounter. Not only do you get them, but any member of your immediate family gets them. So it's a pretty valuable paid benefit that you're getting from the county here. It's a confidential service paid for by the fiscal court and should be viewed as an added benefit. Alcohol and drug-related problems, just one area of service, as I said. Encourage all employees with problems to seek assistance voluntarily before they get caught in the tests. Maybe prescription drugs. My next-door neighbor had some old football injuries, got hooked on the strongest form of Oxycontin there is. Checked himself in rehab, and he's doing great. But he did it voluntarily. Nobody had to prod him to do it. He knew he had a problem and did something about it. But encourage them to do it voluntarily before they get caught in the test, because when you get caught in the test, it's too late. Too late. The county may give you a break and allow you to go to rehab. You can call if you think you got a problem. Nobody has to know about it unless more counseling is required. Obviously, you have to let the county know that you're going to be off for 30 days to do this. But my guess is that the fiscal court's going to give that employee a much better chance of staying on the payroll if they've completed rehabilitation and done all the things that they're supposed to do. But once you get caught in the test, it's almost too late. The phone number for the EAP is listed in materials that you probably already got.